Welcome back to Kelly's Take Two Pre-Licensing Review. We are just making our way like a bullet train through Unit 2. We are moving on to Section 4. Remember, I mentioned that Unit 2 really is made up of 5 distinct sections. And we're moving on to Section 4, which will cover ownership of real property. Specifically, we are going to learn the difference between ownership, different ways you can own property, I should say, with other people. Okay, so let's dive in. I want you to go ahead and grab a piece of paper. If you're going to take notes with me, we're going to draw a graphic organizer. If you are listening while you're out exercising or you're cooking or doing chores or whatnot, again, feel free to speed up the time or the speed of the language or speech with YouTube. And some students really like that. They can get through my reviews much more quickly that way. All right, let me grab my whiteboard and we will dive into ownership of real property. Let's title it that. Let me grab my proper color. Ownership of real property. We're mainly going to focus on owning property with other people, but if you own property alone, so one person owns property, watch this word, this is going to crack you up. One person owns property in what's called severalty. Severalty. There it is. Severalty. You might think, what? Kelly? The word several means more than one. I know, but I did some etymology on this word because it made me so mad when I first started teaching this years ago. Look back on it and it turns out you've got to separate the word into its base and its suffix in a different way. So severalty is actually broken up here. So the root word is sever and the suffix is alty, which stands for realty. Sever, you own it by yourself. I know, I mean, seriously, it's like learning a foreign language with this book. Oh my goodness. Y'all amaze me. You're staying with it and you're doing so great. Okay, here we go. So one person owns property in severalty. You can own property with other people in a variety of different ways. Like what, Kelly? Well, you can own property with other people as tenants in common. You can own property with other people as joint tenants, and we're going to assume survivorship. So I'll put assume survivorship. And in North Carolina, in NC, married couples can own property as tenants by the entirety. It is the default form of ownership. May own property as tenants by entirety. There it is. 3 ways. All right, so we're going to very easily, very simple, very easy. We are going to talk about what distinguishes the 3 types of ownership, how you can distinguish between the 3. So I'm actually going to clear my board and do a versus chart. I think I might do a versus chart or I might do a web graphic organizer. Maybe I'll do a web. Let's do a web. All right, y'all. So go ahead and get your colored pencils, your skinny magic markers out, and let's draw some pictures. Here we go. So I'm going to title this as ownership Okay. I'm not going to go over severalty because I already did that. Okay, so let's do ownership with others. Let's call it that. Ownership with others. And let's do tenants in common. Let's do joint tenants with survivorship. I'm writing fast just for time, so I hope that's okay with you. And then we'll do over here, NC, North Carolina, tenants by entirety. All right, great. So how can you tell these apart? We're just going to keep it very straightforward. Tenants in common is very loose and very easy. So may set up in any percentages. Whoops, percentages. What do I mean by that? That means that I could decide that I want to own a condominium with my best friend, Wheezy. That's my best friend Wheezy. And I might have more money to put down possibly than Wheezy. I don't know. I doubt it, but maybe. And so maybe I own, I don't know, 70% and Wheezy owns 30%. You can do that. You can do anything you want. I've known of people who have owned vacation properties together where one person only owns 3%. I'm like, what does that get you? A Saturday night once a year? I don't know, but you can set it up any way you like. Now, here's the cool part. Each owner may sell their ownership percentage. So I'm going to make a percent sign. Hope you're following with that. May sell their percentage of ownership without permission from the other people, from the other owners. Let's just put others. It's going to be messy. Okay. Sorry about that, but you get what I'm saying. So each owner may sell their percent of ownership without permission from the other owners. Okay. Now, here is a distinguishing feature. Upon death, ownership passes to the heirs. Not to the other owners. Now, this is some of my critical thinkers out there, some of my Mensa Smart students will go, who would ever do that? Okay, I get it for sure. This is the default kind of setup for ownership. Now, hopefully, if you're going to buy property with other people, you're going to consult with an attorney who's going to draw up an agreement, and you can have other terms that you can outline and agree to in terms of what happens if someone dies, yada, yada. But for test purposes, if there is a tenants in common ownership situation, each owner's portion, each owner's percentage upon that owner's death will pass to the heirs. Now that is very different from joint tenants with survivorship. Let me show you that. So let's put that in red. Joint tenants with survivorship, upon death, ownership percent passes to the surviving owners. And nothing can break that agreement. Not marriage, not a will, nothing. That setup, joint tenants with survivorship, is bulletproof. Nothing can break that up. Again, not a will, not marriage, nothing. So upon death, ownership percent passes to the surviving owners. That's the big, big feature. For test purposes, you want to assume survivorship. I know in the book it has some information regarding North Carolina. Let it go, let it go. Focus here, focus here. I suspect you will definitely have a question about this on the exam, knowing the difference. Okay. Let's see if there's anything else I want to tell you about this. Okay. Again, with joint tenants, you can set up the percentages of ownership any way the owners would like to do that. But the big feature, one more time for the 18th time, is that upon death of one of the owner, the surviving owners will take that ownership percentage on. Now, okay, watch this. Technically, each owner can sell. Each owner can sell their percent of ownership without permission. Can sell their percent of ownership, But there's a huge but right here. But. The new owner, oh, you guys watch this. The new owner takes title, takes ownership, takes ownership as a tenant in common, which means their little portion of ownership, if they croak out and die, will pass to their heirs, not to the two original owners. It probably will be helpful if I draw you a couple examples of this coming up here as soon as we go over all three. All right, so let's now talk about North Carolina tenants by the entirety. This is a good one. Let's go with green. Okay, North Carolina. So obviously it's for North Carolinians and it is for married couples, all married couples. It's the default. However, if a married couple wants to take title in a different way, maybe as tenants in common, they just have to request that. But if they don't make a request, then they will own the property as tenants by the entirety. What does that mean? That means that they each own 100% together, percent ownership together. In the eyes of the law, they're seen as one entity. That means if someone dies, so upon death, the surviving spouse owns the property, owns 100% of the property, no fuss, no muss. It doesn't go to the kids. It doesn't go to any heirs. That surviving spouse gets the whole kit and caboodle. No fuss, no muss. We don't have to do anything about it. It's just automatic. All right, but watch this. Now they're going to own 100% of the property. Watch this terminology, in severalty. So as one person. Very good. Okay. Interesting tidbits that you may encounter at least on a practice exam. How does tenants by the entirety end? Ends via D&D, and I don't mean Dungeons and Dragons. I mean death or divorce. If tenants by the entirety ends because of death, then the surviving spouse, like I just said, owns 100% in severalty. Whereas if it ends in divorce and they don't have a great divorce attorney who's going to help settle their assets, maybe they're just doing one of those $200 divorce attorneys or something. I have encountered that in real estate, y'all. What a mess. Okay. So if it ends in divorce, then the how do I want to call them? The couple owns 50-50 as tenants in common. So get yourself what? Get yourself a good divorce attorney. Just don't leave that out there waggling. Will make for a horror story. You don't want that. Okay. Let me see. What else did I want to tell you? Oh, right. Now, let's say that what I'm about to tell you is not going to involve North Carolina tenants by the entirety, but it will involve these two forms of ownership. If we want to end the ownership and people are arguing about it, like let's say you've got three people that own a piece of property together and one person is being argumentative or some such thing, but they can't work it out in order to settle it amongst themselves in a amicable way, then they're going to have to go to court and they're going to file what's called a partition suit. So that term is fairly testable, a partition suit. With a partition suit, the judge is going to figure out how to split this property up so that it reflects the percent ownership in terms of either the amount of property or the proceeds from the sale. All right, guys, great. Okay, let's go ahead and draw a few of these out, and then we'll end this short review of Section 4, Unit 2 on owning property with others. So I'm going to clear my board. What's so great about these reviews is you can pause and stop and replay and all of that. You don't have to feel like you have to keep up with me. Okay, here we go. So let's draw a few examples of ownership. When you get an ownership question on the exam, go ahead on your scratch paper and draw a circle. This represents 100% ownership. Let's say that we've got three people here. Obviously, this is not drawn to scale. We've got Malik. We've got Kaya. And we've got Chris. Okay. And let's say they own this property as tenants in common. I'm going to put TIC for tenants in common. Very good. Let's say that Kaya has a life change of some sort and needs to sell. So Kaya is going to sell to Betty. No problem. Good to go. Okay. Let's say that Chris dies. His portion of ownership will go to his heirs. Let's say that Malik dies. His ownership will go to his heirs. Let's say eventually Betty dies. Her portion of ownership will go to her heirs. Now look at this. We've got this one property. Let's say it's beachfront property at the coast, the Outer Banks maybe. And now we have this beachfront property owned by all of these heirs that do not know each other at all whatsoever. And let's say this beachfront property is worth $2 million. $2 million. What do you think these heirs are apt to want to do? If you say sell the property, you are 1,000% correct. Ding, ding, ding. But let's say these heirs don't want to sell. No, we like the beachfront property. Sorry, guess what? These heirs want to sell. Yes, we want to sell. So yes, sell it. Let's get the money. So what are they going to do? They're going to file a what? They're going to file a partition suit to force the sale. And that's a whole nother, I could get on a soapbox about a forced sale via a partition suit. But generally speaking, you're not going to get a fair market value. Oftentimes those are sold lickety split on the courthouse steps for way below market value, which is unfortunate. But anyway, any one party, when you have tenants in common, can force the sale via a partition suit. All right, let's do another one. All right, draw your circle indicating 100% ownership. Okay, let's do 50-50. This time we're going to do joint tenants with survivorship. Okay, and let's say you've got cousin Kelly, that's me, and my cousin Dawn. How fun. And let's say that cousin Kelly and cousin Dawn bought a condo when we were in our 20s. We bought a condo together as what? Joint tenants with survivorship. What does that mean? That means that if Dawn croaked out, let's say Dawn croaked out, that I would get the entire condo 100%. That's what survivorship means. But let's set it up a little bit differently just to drive this point home. Okay, let me draw her name again. Okay, so here's cousin Dawn. We were so smart that we bought a condo together in our 20s. We really didn't. We rented one, but there you go. All right, so let's say that this time cousin Kelly and cousin Dawn, we were in our 20s. So now let's say that Dawn gets married. She marries a guy named Jim, which she really did. And I set them up because I am an amazing matchmaker. I digress. Okay, here we go. All right, so she marries Jim. Let's say that something tragic happens, and I wish this upon no one, but let's say something tragic happens and cousin Dawn dies unexpectedly. Okay, who gets the condo? Who gets the condo? Does Jim get the condo along with Kelly? Yes or no? If you said no, you are correct. If you've got joint tenants with survivorship set up right here, we don't care about Jim. Bye, Jim. Bye. Go away, Jim. We don't care. Why? Because this type of ownership is bulletproof. We don't care if someone gets married or even is married. Doesn't matter. If cousin Dawn dies unexpectedly, cousin Kelly gets the whole ding dang condo, 100%, no fuss, no muss. Jim has no right to that condo whatsoever. Nothing can break up a joint tenants with survivorship. End of story. Okay, y'all. I hope that was helpful. Talking about owning property with other people. Remember, you want to think about how does ownership end upon the death of one of the parties, and how can we, what's the suit called when we have to break up an ownership interest if there's an argument. Remember, that's called partition suit. All right, I'll see you in a few minutes and we'll go over Unit 2. Part 5, Section 5 on hybrid ownership. Let's go.